Welcome, welcome, welcome. We have a few people trickling in. There's a few more seats in the front if anyone needs a seat. Good evening, welcome. It's just such a pleasure to have you all here this evening. I want to welcome all of the students, our colleagues, members of the Brown community more generally. It's just such a pleasure to have you here this evening. I'm Emily Skarbek. I'm an associate professor of political economy here with the Center for Philosophy, Politics, and Economics. And I'm here to welcome you to this evening's Janus Lecture. So our Janus Lecture series is a signature feature of the Center for Philosophy, Politics, and Economics, and serves to advance critical thinking and civil discourse in the service of elevating scholarly and public understanding of pressing social issues. Okay. So by bringing together leading intellectuals with different viewpoints, different perspectives on a pressing topic, we hope to gain from the fruitful exchange of ideas with one another and with our guests. So one of the distinctive features of the Janus Forum Lecture is that we reserve a significant portion of the time period this evening for a lot of question and answer from the audience. Okay, so we hope you'll take advantage of that opportunity. So it's my great honor and privilege to welcome you to tonight's discussion on originalism and constitutional interpretation. The role of the Constitution as the bedrock of our legal system has become more significant and in many ways more controversial than ever before. So in recent years, the Supreme Court has ruled on some of the most important areas of constitutional law, including the scope of the Second Amendment, abortion rights, presidential immunity, free speech, affirmative action programs, and college admissions, and regulatory deference to administrative agencies. So just a few, slightly important things. Originalism as a judicial philosophy is at the center of many of these contentious court decisions and is reflected in various capacities in the current composition of the Supreme Court. Originalism suggests interpretations of the Constitution be based on the meaning it had when it was written. But how and why should a document crafted in the 1780s inform the practical applications of law today? So this evening's lecture promises to be a very thoughtful exploration of originalism's theoretical foundations, its practical implications, and its place in shaping American civic life. So we hope this conversation is an opportunity to deepen our understanding of the principles that guide our legal framework and to critically reflect on how and why, and perhaps why they should and shouldn't inform our path going forward. Okay, so with that, I'll introduce our speakers. We have two very interesting and exciting and electric speakers to come talk to you this evening. Akhil Amar is here as the Sterling Professor of Law at Yale University. After graduating from Yale summa cum laude in 1980 and law school in 84, he's clerking for, he clerked for Judge and then later Justice Stephen Breyer, and finally joined the Yale faculty at 1985 at the young age of 26 years old. He's Yale's only living professor to have won the university's unofficial Triple Crown, which includes the Sterling Chair for Scholarship, the Devane Medal for Teaching, and the Lamar Award for Alumni Service. So Professor Amar has been cited by the Supreme Court justices across the spectrum in some 50 cases, which basically tops among living non-emeritus scholars. So you've got a record there. He was an informal consultant on the TV show The West Wing. Okay, an author of more than 100 law review articles and several books, including the one in which he has graciously made available to you free of charge his most recent work, The Words That Made Us, America's Constitutional Conversation from 1760 to 1840. So in 2021, he and Andy Lipka launched their free weekly podcast, America's Constitution, which is rivaled perhaps only by the great Advisory Opinions, which Sarah is the host. So it's my pleasure to introduce Professor Amar. Please join me. So it's my pleasure also to introduce Sarah Isgur. She's one of our nation's most sought-after legal and political commentators. Sarah's previously served as the spokesperson for the United States Justice Department. She's worked in key roles on a number of big-ticket political campaigns, including notable figures such as Mitt Romney and Carly Fiorina. As part of Fiorina's campaign, Sarah served as the deputy campaign manager and was by her side during more than half a dozen debates as part of that presidential campaign. In addition, she served as the deputy communications director for the Republican National Committee and is also a research fellow at Harvard and Baylor, among other roles. So today she's serving as senior editor at The Dispatch and also of the incredible podcast Advisory Opinions. And she's a regular contributor to Politico and a contributor to ABC News. So we're just thrilled to have the two of you here to share this conversation with us, to share it with all of the students and everyone else in attendance. So the format of our program will follow in this way. Professor Amar will speak for about 20 minutes, giving his kind of succinct presentation of his views on originalism. We'll then turn to Sarah, and Sarah will also have 20 minutes for her remarks on the same topic. And then we'll have a little bit of opportunity for some back and forth, some commentary from both of you before we turn it over to all of you to ask your questions and comments. So there will be plenty of time for Q&A. There's 2 microphones set up on either side of the room. We ask that you queue up right away to start asking questions. In order to make the most of our time, please do try to frame your question as a question and be succinct so that we can allow as many people an opportunity to engage in this as possible. So without further ado, join me in thanking both of our speakers. All right, Akhil.
So it's a great privilege to be here. Is this on? Okay, great. You can hear me. And thank you so much for inviting me. If I'm lucky, I might even be a little bit shorter than my allotted time because we're here to have a conversation not just with each other, but with you all. Why? Today. It's Constitution Day. Now, you know that July 4th is Independence Day. Many of you know that June 14th is Flag Day. September 17th every year is Constitution Day. It marks the day in 1787 when the Philadelphia Convention basically disbanded, and went public with its plan, its proposed Constitution for the United States of America. It had met behind closed doors, and now actually it releases this plan. It's of no legal significance yet. Then over the next year, it's going to be voted on across a continent. And newspaper, it's short, not so that judges can make stuff up. It's short so that ordinary people back in 1787 could read the thing start to finish in a newspaper. Yes, there were these things back then, they were called newspapers, and people read them. And even before there is a First Amendment, there is freedom of the press, and the press is free to publish this plan or not, and most of the press actually chooses to publish this plan because the newspapers actually back then, believe it or not, printed news. And this was news. Here's a plan for how the continent should be governed. We're going to get to vote on it. So the newspapers published it start to finish, beginning basically on September 19th. Often the words of the preamble were in especially large type, not because anyone told the printers that they had to do that, but because they realized that that was actually significant. The words are so familiar to you all that you don't really pause to think about what they are saying and doing. Yes, they give you some reasons. This Constitution is designed to form a more perfect union, to promote the common defense, to preserve the blessings of liberty for ourselves and our posterities, but just put those aside. And that's pretty impressive because law often doesn't tell us why. It just tells us what, do it, do this, don't do that. But it's actually telling us why. But more than that, just take away, some of the grammatically superfluous verbiage, cut to the essence of the thing. The subject, the verb, the object. Since my friend Sarah is, a political operative, I think they said, back when Rudy Giuliani, before he had disgraced himself and he was running for president, every campaign speech, every sentence of every campaign speech featured a noun, a verb, and 9/11. I think. Okay, so here's actually stripped away the verbiage, the noun, the verb, and the object. We, the people of the United States, that's the noun, do ordain and establish, that's the compound verb, this Constitution for the United States of America. It's not just a text, it's a deed. We're doing something. We're putting the thing to a vote, and if the deed hasn't been done yet. You see, this is the script of, in effect, a wedding still to be performed, a contract still to be accepted. But we are about to do something. We, the people of the whole United States, up and down the continent, we're going to actually ordain and establish a constitution. And that year-long process begins on September 17th, 1787, and we call that Constitution Day, call it Constitution Week. And I claim it's the year that changed everything. It's the hinge of human history. Never before had so many people been allowed to vote on how they and their posterity would be governed, and not just vote, but discuss the thing up and down the continent. And you could be for it, and you can be against it, and you're not going to be voted off the island either way, which is impressive. And now I'm starting to slide into why you might want to be an originalist, to take seriously the project that began in that dramatic way. I'll tell you a little bit more about this book, The Words That Made Us, and it's a pun. Us is the U.S., how we become a we become a people, because we're not actually at the beginning of this book, 1760, and we become a people. We declare our independence. These are not my forebears, but I can choose to affiliate with this project or not, just as you can choose to affiliate or not. But at the beginning of this book, we're not quite a we. We're New Yorkers and Virginians and North Carolinians, and we're not even talking to each other very much in 1760. But for reasons that you'll see in the first couple of chapters, we begin to come together and talk to each other. Britain actually misbehaves in various ways. And through newspapers and other things, we begin to converse with each other. The subtitle is America's Constitutional Conversation. Through things like newspapers, we begin to talk to each other. We declare our independence in July 1776. What day did we declare our independence, by the way? Oh, yes, well played. The Declaration of Independence is adopted on July 4th, but we declare our independence. We, and again, we do, declare that these colonies are and of right ought to be free and independent states. That's the key language, the payoff language, not so much the hold these truths to be self-evident. That's the perambulatory stuff, but the doing, we do, July 2nd, and then 2 days later, we tell the world, we submit facts to a candid world about why we're doing this. Because law rarely gives reasons, but we tried to give reasons. So that's July 4th. But the Declaration of Independence, you see, is not put to any kind of special popular vote. And neither is the governance structure of USA 1.0, which is called the Articles of Confederation. It's a NATO-like treaty, an alliance, a league. It's drafted in they begin drafting in 1776, even before the Declaration of Independence. They're starting to work on this project, and it's eventually ratified by the states in 1781. And it fails for all sorts of reasons, and people meet in Philadelphia to try to come up with a plan that will work. We call that the Constitution, and on September 17th, 1787, the plan is unveiled. And now this time, see, so the Declaration isn't put to a vote. Oh, and the Articles of Confederation aren't put to a special vote of any sort. None of the state constitutions in 1776 was put to a vote of any special sort. Eventually, Massachusetts will put a constitution to a vote that gets popular support in 1780, and New Hampshire will follow suit in 1784. 11 of the states adopt new constitutions. Not Rhode Island. Rhode Island, there are always issues with Rhode Island, but we won't go there immediately. But in most of the states, other than New Hampshire and Massachusetts, these amazing new constitutions are not put to a vote, a special vote by the people themselves. And the U.S. Constitution is, in this year-long process, the hinge of human history. I call it the year that changed everything, that begins on September 17th, 1787, and the world will never be the same. After an entire continent has gotten to vote on how they and their posterity are to be governed, because such a thing had not only never happened in America, it had never happened in the world. The history of the world before 1787, we look and we see all the exclusions and the limitations. Women didn't vote anywhere except maybe a few in New Jersey. There were some property qualifications in some places. In many places, there was slavery almost everywhere, although some states are in the process of getting rid of it, and indeed have already abolished it by 1787, the northern states. So if you look at it from the perspective of today, you'll be deeply disappointed. But historians are taught to look at things also from the perspective of the time in which they take place. And to do otherwise is for an historian to be, the word is anachronistic, to look at things out of time. So you have to compare 1787 to 1786, 1785, and all the 85s before it, going all the way back to the womb of time. And here's what you see. Before we, and again, they're not my forebears. I'm choosing. My family comes very late into the story. They're choosing. They are to put the thing to a vote. But before then, the history of the world, every 85, all the way back to the dawn of time, is basically in almost every place and almost every year. It's a history of kings, emperors, czars, sultans, Mughal lords, tribal chieftains, thugs, all. It's a history of early versions of Adolf Hitler and Pol Pot and Saddam Hussein and Joseph Stalin, Vladimir Putin, and the like. Just thugs. There are a few self-governing societies that manage to sprout up, flourish for a brief flicker of time, and then fade. There's ancient Athens under the Cleisthenic constitution in the age of Pericles. There's pre-imperial Rome before Caesar comes along, and eventually even imperial Rome will fall. And there are a few others, but these places in general aren't able to sustain themselves against external attack and against internal dissension. At their best, they're tiny little city-states. They're smaller than Providence, Rhode Island. All these people worship the same god or gods, speak the same language. They're not broad multicultural societies. They're all slave societies. All societies are basically slave societies of one form or another. Slavery is ubiquitous. It doesn't begin in 1619 in the world, when the first slaves reached Jamestown. So, and now, against all that, in 1786, you look around the world, who governs themselves apart from Americans? Well, they're the Brits, but they've got a king no one voted for, and a House of Lords no one voted for, an established church. But they have some self-governance, juries, and some elections, although maybe, 1 in 20 men would be allowed to vote, something like that. That's about it. And then there are the Swiss, but they have, truthfully, more sheep than human beings, and so they're not that, they don't have banks, so no one's really interested in them yet. The Dutch are in the process of losing their self-government, and that's it. And then we, the people of the United States, and again, to repeat, Declaration of Independence not put to a vote, none of the state constitutions, 1776, not the Articles of Confederation, and then we, the people of the United States, in this year that changed everything, the hinge of human history, beginning on September 17th, put the thing to a vote, and the world will never be the same, because now, by population landmass, half the world is self-governing, imperfectly so in many places, in Poland, in Hungary, in the Czech Republic, in Ukraine, in Western Europe, maybe a little bit more successfully. At the time, an absolutist tyrant, sits on the throne in France, and now it's a pretty impressive republic. It's not as impressive as California, which I'm not commenting on the wine, but California treats its minorities better than does France. Japan, plus or minus, governs itself. India, my dad's still alive, and when he's born, a guy from halfway across the world is telling him what to do, sitting on a throne, and a parliament that no one voted for is telling him what to do. And now it's imperfect, but these are 1 billion people, multicultural, multilingual, multi-religious. They have a constitution. They have pretty much free and fair elections, not perfect, but neither are ours. They've got courts and parties that alternate in government. And I say this is not just after, but because of the Big Bang in human history. I wrote a book on this that you don't have here. It's called America's Constitution, a Biography. Chapter 1 has the immodest title, In the Beginning, as in not just Genesis, but the Gospel according to St. John. In the beginning was the Word. And the first sentence is, it started with a bang. And it did. This project has given an impetus to the rest of the world. This imperfectly democratic project has exploded in America. We add a Bill of Rights. We end slavery. We let women vote. We let 18-year-olds vote. It has, the project has grown in America in time and expanded in space. That's a reason to be originalist of a certain sort, to take this project seriously, because it's pretty impressive. People voted for it. More people voted for it than had ever voted on anything else before. And in 8 of the 13 states, ordinary property qualifications were lowered or eliminated for this special ratification project compared to what the ordinary rules were. Nowhere were they raised. Oh, you weren't taught that in that horrid book by Howard Zinn, okay? He didn't tell you that because either he didn't know it, which is not good, or he knew it and he didn't tell you, which is not good, but that's a pretty important fact, you see. Now, just say a couple of more things and then I'll shut up. Originalism. What's originalism? It's taking seriously the Constitution. As opposed to what? Well, as opposed to what the judges say, and I clerked for a judge, and I know most of the justices, and I'll be straight with you, they don't impress me as much as we, the people, over time do. Okay, they're a small group, they think too well of themselves, and to the extent that they've deviated from this, it's generally been actually less good than the document. You might think you've been taught, and we take an oath to this. Okay, and if you take an oath to this and not to the case law, then this is what you take your oath to. If you're a judge or a justice, I, Donald J. Trump, do solemnly swear that I will faithfully execute the office of President of the United States and will to the best of my ability preserve, protect, and defend the Constitution of the United States. And you can add so help me God or not. And Joe Biden said that, and Kamala Harris may soon enough. It says it word for word in the document. That's what we have to take an oath to. And I think it's not just the text, but the text as understood by the people who were, they were trying to do a certain thing. Now, today's Constitution isn't the same as the one in September 17th, 1787, because the first thing ordinary people do is they say, dude, you forgot the rights. And they did, okay? And they were in state constitutions, so a Bill of Rights is added, and then later slavery is abolished, and blacks are given equal citizenship and equal voting rights, and women too, and in my lifetime, 18-year-olds get to vote. That's actually uh, the best kind of originalist, not the Scalias of the world, but the best kind, who's not a very impressive originalist in my view, the best kind of originalist takes seriously not just the Constitution of 1787, but all the amendments, the making of amends, the Bill of Rights, the Civil War, the Progressive Era, the 1960s. And we should take it seriously because it's a democratic project, because if we don't like it, we can change it. And we have over time. Today, it might seem impossible because we're so deeply divided. Half the country wants to take us, hard right. Half the country wants to take us hard left. That's an unpromising situation for radical change. But you can't blame the Constitution for that. You have to look in the mirror and look at your fellow citizens. But we have done it many times before, and the amendments have made the thing better. In generally, the cases have gotten better or worse. We've had good presidents and bad presidents, and they've alternated. The Constitution was better than what came before, and the amendments have made it better still. Maybe the 18th Amendment wasn't so good, but that's prohibition. But we got rid of it pretty quickly with the 21st Amendment. But otherwise, I really wanted you to tell me why these amendments are bad. I would say they've made us more free, more equal, and now it's compared to what? Compared to judges in their infinite wisdom? The text says equal. Judges didn't do that for the longest time. They gave us apartheid in Plessy versus Ferguson. The text said freedom of speech, and judges didn't do that for the longest time. The text says right to vote, and judges weren't protecting that. Text doesn't say so much about right of corporations, but courts actually, robustly protected that for the longest time. You've been taught originalism is some conservative thing. I don't think I've been saying lots of conservative things. I don't think the Constitution is intrinsically conservative or liberal. Some provisions are liberal, some are conservative, some are just deeply American and very good ideas, and we can coordinate around them. So if we don't have this, and here I end, what do we have? Okay, because look to your left, look to your right. We Americans don't have that much in common. We don't have race in common. We don't have religion in common. Geographically, we're vast, very diverse, the different quadrants of the country, north against south, coast against the center, cities against the hinterlands. Some of our families came hundreds of years ago in chains. Some came hundreds of years ago with bullwhips in their hand. Some came yesterday. And apparently, according to some, are eating dogs and cats. Who knew? And we don't have Shakespeare to unify us, or Goethe, strong language. We don't even speak English all as our first language. Politics deeply divides us. The only thing we have in common is our Constitution and the story behind it. And I want you to know that story. I want you to read the book, so that you can actually do your duty and pick good presidents, because you actually know something about the earlier presidents. And it will give you something in common with your fellow citizens. And if not that, what? The Supreme Court, we can talk about that. I don't think it's been that good. If not that, the professoriate. So enough said. And in fact, if not that, actually, we have nothing. We have Beirut. Beirut's not such a great place, truthfully. I think we have inherited an amazing project. We can choose to carry it forward. We can make amends to it. We can give our children a better constitution than we've inherited, just as people in the 1960s did when they let 18-year-olds vote. And got rid of poll tax disfranchisement, just as people in the 19-teens did when they added women's suffrage to the project, just as Lincoln's generation did, just as the founders' generation did. That's pretty much what originalism is actually all about. And I think, begun to give you a little bit of a sense of the case for it, how it connects to this day, September 17th, and this book, which I do hope you read. Thank you.
Gotten to hear him speak so many times, and he's been on our podcast several times. They're some of my favorite episodes, and every time he finishes, you just kind of want to like stand up and say the Pledge of Allegiance and sing the national anthem all at the same time. So what I'm going to try to do is take us from 1787. We're going to zoom real fast through the 19th century. We're going to slow down a little in the early 20th century, and then we're going to slow down a lot when we get to sort of the era of originalism and break down sort of the three eras, Taylor Swift style, of originalism, where we are now, like today, and some of the problems that are coming up as we try to decide what originalism is. So let's start with the Supreme Court. I'm going to focus a lot more on the Supreme Court than Akhil did. Right away, you've got John Jay as your first Supreme Court justice and
Chief Justice.
Chief Justice, and you could write a whole book on poor John Jay. He has an incredible career, and this is really it would look to us like the capstone of the career, and instead, over the course of his 6 years on the court, he hears 4 cases. At that point, the Supreme Court, it just looks nothing like what you think of it today. There's no majority opinion, just each justice gives you their thoughts. And then you can take that for what you want and you move forward. John Marshall is really going to create the Supreme Court as we know it, and there's something anti-originalist about that, if you will, as in it takes many years before the Supreme Court, even if its most nascent sense, is going to look like what we have today, to have judicial review. It is the province of the judiciary to say what the law is. That's John Marshall. That's not in the Constitution. And there's something maybe not originalist about that from the get. And, there's like a zillion books on John Marshall, so feel free to dig in on him. I want to talk about Justice Taney for a second. He's, of course, the Chief Justice who decides Dred Scott. He writes the majority opinion in that case, holding that not just those held in bondage in the United States are not citizens with the rights of the Constitution, but any black person, free or slave, is not a citizen of the United States. It is a catastrophic opinion. It's going to lead to the Civil War, 600,000 deaths, and the rebirth of the United States, and something hopefully we'll get into, the 14th Amendment. So when we talk about originalism, we talk about 1787 quite a bit. You're also going to talk about 1868 quite a bit, because there's going to be a second founding of the United States because of Justice Taney. By the way, Taney, for you undergrads, I pronounced it Taney for like a real long time, so I'm just going to help y'all out there, because if you then move to D.C. and live near Maryland, there's still a lot named after him, and they say Taney. I think it's worth noting why Dred Scott comes out the way that it does, though, because it's very easy, I think, to your point, for us to look back and just see, evil people doing evil stuff. Justice Taney is not a particularly into slaves kind of guy, actually. So how does he author this opinion? How does he make such a catastrophic mistake on behalf of his country that he loves and has served well and seriously through his career? And the answer is because of the role he thinks he has as Chief Justice. And I would argue that he's our least originalist justice, to your point, that when judges see their role as the, 9 platonic guardians of the United States and to do what they think is best on behalf of the people, that's how you get Dred Scott. So the Missouri Compromise was flim-flamming around. New territories were getting added. You had bloody Kansas happening. Again, we're not going to spend a ton of time on this. So Taney thinks he knows better. He thinks Congress messed this up, that their rules on adding new territories to the country, on how to deal with the slavery question, they were just wrong. They were bad at this, and it's not working. And he, Roger Taney, knows better. That's how Dred Scott happens. And so when I think you talk about the benefits of originalism, you always have to ask, against what? Originalism is far from perfect. But against what? Against Roger Taneyism. Against the idea of judges simply saying, yeah, you know what? I think it would be better if we tried it this way, with no ability to go back. That's what causes the Civil War as well. If Congress's Missouri Compromise is unconstitutional, there is no democratic process left. That's why you have to have the Civil War, because of Roger Taney eviscerating Congress. Okay, we're going to move ahead from Roger Taney now. We're going to go to Plessy v. Ferguson, the second greatest sin of the Supreme Court. Except don't focus on the majority. They're all just normal, pretty racist. We're not going to defend them much. But we're going to focus on the dissent, right? That's a 7-1 opinion. And the greatest justice that the Supreme Court has ever had, and I don't even know that there's any debate or who would even argue is second. It's just John Marshall Harlan is number 1, and there's nobody in the next 10. He's like LeBron and Michael Jordan had a baby of justices. And his dissent in Plessy v. Ferguson is amazing because he's not a brilliant writer. There is a couple sentences that are quite soaring, I think, when you read them now, but by and large, this is not poetry. There's a reason, you don't have it, tattooed on you right now. But he's right. He's right because he's reading the text of the 14th Amendment, and he's looking at this Louisiana rail car law. Fun fact about Plessy, by the way, is it is a test case. They, in fact, hire a police officer to arrest Homer Plessy because they're afraid that the actual Louisiana authorities won't. They call the rail car company in advance. They hire a private police officer. So the whole thing is a test case. And this comes up from time to time where one side's mad that something's a test case or the other side's mad. And that's not fair. You shouldn't be able to bring test cases. But they've been going on the whole time, y'all. That's how this works. Harlan writes in what I think is this beautiful moment, matched only in our law by when we allow the Nazis to march in Skokie, where we speak to our values more than our moment and more than the day that we are born into. And that's what he does. He is 7-1. The culture is not with him. Frederick Douglass writes to him afterwards and says, "One man with God is a majority." That you should have a tattoo of, by the way, because that is a beautiful sentiment from Frederick Douglass when there were so many hopes pinned on this test case that fail. But Harlan's dissent is written for us. It's written for posterity, not for the moment. And he's making an originalist case about what the 14th Amendment means at that point. So again, I guess I want you to think about Dred Scott versus the Plessy dissent as being your extremes of constitutional interpretation. Okay, now we're going to head into the progressive movement. That's what he's talking about with corporations and a bunch of sort of nonsense stuff. What causes the progressive movement? And by the way, not our progressives. The left and the right are both progressives at this point. Teddy Roosevelt's a progressive. Woodrow Wilson's a progressive. There's a few parts of progressivism that I think are worth us highlighting here. One is the idea of the perfection of man. That's how progressives are going to get super into eugenics, right? They can perfect government. They can perfect us. We're going to breed the good people. We're going to sterilize the bad people. Oliver Wendell Holmes writing 3 generations of imbeciles is enough. Why we honor him as a justice, whatevs. He's going to get revisited like Woodrow Wilson and we're going to strip his name off stuff soon enough. Oliver Wendell Holmes. But another part of the progressive movement that I don't think gets enough attention is their idea that they look at the Constitution that Akhil is so beautifully eulogized, perhaps, and and they see in its truth what is a counter-majoritarian document, right? Most things are left to majorities, sure, but a lot of things are not. The government doesn't have certain powers, certain rights. The government doesn't have. Your right to free speech is a counter-majoritarian issue. 2 houses of Congress before anything can get to the president. That's counter-majoritarian. The veto power is counter-majoritarian. All of these things built in for the purpose of stability over time. The idea that if you've compromised enough and negotiated enough that you're able to get through all of these hurdles that the Constitution lays before you, it will have gotten the most number of people possible and their voices heard to make that change. And the progressives thought This is taking for effing ever to get anything done. We know best, so let's not do so much of what the Constitution says, and let's just fix all of this because we know how to fix it. Again, you're going to end up with all sorts of, I would say, very negative consequences from that, and I think we're feeling them today. The idea of administrative agencies filled with experts who know better, rather than forcing those questions to go through Congress. It helps with speed, and it hurts with stability. It's why each administration just has a totally different plan for climate change or immigration or anything else. Congress doesn't have to do it because the administrative agencies will do it. That is a part of the legacy of that progressivism. Okay, so then we're going to have the Warren Court. Warren, by the way, Republican governor, he's the politician's politician. They put him as Chief Justice so that he won't run for president again and be a rival. So the Warren Court's the ultimate egotists. They're just gonna like pew, pew, pew. I love most of what they did, to be honest, but like that's not originalism. The Brennan Court, they're overturning precedent at a pace we have never seen since. About 3.4, 3.2 a term during the Warren Court and the Brennan Court. You're then going to get to the Rehnquist Court, and that's where originalism is going to be born. It's going to be a reaction to all of this stuff that we've talked about previously. The first originalism is simply like, look, we should probably look at the text of the Constitution before we decide these cases. There's a whole strain of cases where it's like they never even bother to like open up the book. That's not going to last for very long because, okay, you get some of that low-hanging fruit. Most of what we're talking about is when we look at the text and we don't know what it means as applied to whatever factual scenario we have today. This is going to be part 2 of originalism. This is the longest era that we've lived in, and it's just ended. This is the Scalia era, originalism 2.0, original public meaning, where you try to discern what the ratifiers, all those people who got to vote, what they thought they agreed to. Think of this like a contract. They get all the low-hanging fruit off the trees with originalism 2.0. Justice Scalia dies. And conservatives, you almost can feel, were champing at the bit for a post-Scalia era because they weren't really getting to address a lot of the problems that left behind. Originalism 2.0 was still pretty ambiguous at times. How do you determine the original public meaning of that language? We can't go ask the people who voted for it, and so it becomes quite circular. This is where we're going to get to originalism 3.0. Welcome to the current era. We're trying to run a country. This is the text, history, and tradition era of originalism. And it's the idea that you look at the text first, originalism 1.0, the history around that, but not the intentions of people, not the purpose of people, but, you know, perhaps was this something that we were trying to fight King George about? Or was it something we were trying to take with us as part of our, British, heritage? And then tradition, which nobody knows what that means. And that's where we are right now. And you're seeing this battle for the soul of originalism at the Supreme Court in the Rahimi case from last term, a question about whether the Trump administration, that's a different bump stock case, which I have a whole album side on that case. Rahimi's like the worst dude ever. This is like someone that had just, the best part of the whole indictment is that he goes to Whataburger. I'm from Texas, so like, I feel this. He goes to Whataburger, they order their burgers, and his credit card gets declined, and so he takes out his guns and just starts shooting. He shoots at his girlfriend. He shoots at his next girlfriend. He's shooting at the Whataburger. There's assault charges. There's attempted murder charges. There's domestic violence charges. And the question is, can we disarm this guy? Or does the Second Amendment protect his right to own a gun if he hasn't been convicted of any of those things? What if we just know he's dangerous and there's a domestic violence restraining order? In fact, there's 2. And we have a law that says that we can disarm people just if that restraining order is still in place. And the Supreme Court says, yes, you can definitely disarm that guy. And then there's 8 different opinions as to why you can do that. There's one dissent, by the way, Justice Thomas, who's like, wait a second, this isn't the text, history, and tradition that I created, that I was waiting this whole time for Justice Scalia to die so I could introduce. And you have Justice Gorsuch saying, yes, it is, old man, you just don't recognize it. You have Justice Kavanaugh basically like putting on his hat and being like, hi, I'm actually the swing vote, and nothing you guys say matters in terms of what you think this means because I'm in the majority 96% of the time. You have Justice Barrett, and you're starting to see her thoughts and feelings on the court, being her own person for sure, and she has a concurrence that says, like, look, I get looking at the text, check. Looking at what happens leading up to that text, where there are debates in the Constitutional Convention, things like that. History, check. But this idea that after the Constitutional Convention, we then look at like what states had what laws to think about what people like basically to try to glean that original public meaning. Here's what they must have thought the Constitution meant because they passed state laws that said X. She's a real gnaw dog on that one. And then, of course, you have the various liberal justices with their own opinions of how you apply originalism in this case. And so I want to point out two of what I think are the biggest questions left unresolved for text, history, and tradition, this originalism 3.0. And it's what I've called a horizontal problem and a vertical problem. And Rahimi is all about that vertical problem. The vertical problem is, if we're looking back at the time of the founding and the ratification, how close does the law need to be able to say that we have a history of that type of law now? Is it just, for instance, to continue with our gun analogy, we had a history of disarming dangerous people? Okay. Does it need to be we have a history of disarming people with domestic violence restraining orders? Because God knows we weren't doing any of that. Or is it we have a history of laws against bad people? Like really, really general, we're just for good things and puppies and rainbows? Because at some point it becomes so specific, you can't do anything. And at another point, it's meaningless. And so the court's really struggling with that vertical, what level of analogy? That's why Justice Thomas dissents. He says, you weren't disarming people based on basically domestic violence at that point without a conviction. There was nothing like that. And you have the Chief Justice saying, yeah, but there were like all these different ways if you basically ran around making people afeared, then you would have to pay money to keep your gun. And if you then did something wrong, it was almost like a bail for your money. They would take your money. So it was like your assurance. It was called a surety law. And the Chief Justice is like, good enough. Justice Thomas thinks it isn't. That's the 8-1. So that's your vertical text, history, and tradition problem. At the horizontal level, we've also had an interesting case from the Fourth Circuit with one of the most famous conservative judges in the country who's not on the Supreme Court, Harvey Wilkinson, on an assault weapons ban. And his argument is, well, okay, yeah, there weren't laws banning things like assault weapons at the founding, but there also weren't mass shootings at the founding. And so what we need to do is sort of wait until the problem arises. And then we look and see whether we have a text, history, and tradition of these types of regulations and laws. And we don't really have gun crimes because it took so long to load the weapon. You were better off just stabbing people, frankly. So we don't have these types of gun crimes until the guns become more effective in the 1920s. And then boom, all these sorts of laws pop up about different weapons that are banned, Tommy guns, machine guns, etc. And so that's your horizontal, your timeline problem. When do we look to determine when we think we should have had such a law? Because just because Congress didn't make a law in 1790, maybe they didn't because it wasn't a problem or because they thought they had the power, they just didn't need to. They had other priorities. And so you can really limit Congress's power on its own. So those are, where originalism, I think, leaves off today. I'll also just mention that what the solutions are and some of the things I hope we can talk about in our conversation and Q&A is Congress being broken in all of this and that causing some of these problems, and also the amendment process potentially being broken as well, and it being the solution you brought up, the only solution the Constitution provides us, and what we do in that sense. The end.
Akhil, do you want to take a few minutes to respond or give any further remarks?
We could get the audience in. I'm happy to get them in. What do you think?
Yeah.
I've got some slides on guns if people are interested. That might be, but let's see what people want to talk about.
All right, well, if you gather your thoughts and find your way to a microphone, we can start kind of opening up this question on kind of anything that we've laid out already.
Do you have a question? Oh, no, I have done this so much, and women never ask the first questions, and I'm so proud of you.
She gets the first question.
Yes, finally. I have certain things to tell when we've reached women's equality, like are there enough women in first class, like on an airplane, because otherwise it's all men if the temperature is above 68, and this is one of them. So
I think her name is Maggie.
Maggie.
That is, thank you. So yeah, I'm actually somebody who recently passed the bar, and so I'm very interested in this topic. Thank you. And so the brochure that came with this talk said that you're kind of on other sides, right? And I found your talks to sort of go weave a story together. And what I thought was, well, can't you sort of combine both of your ideas to create a better future government system? Because in some ways, the Constitution is, like you were saying, the originalism. It's so important, and it helps us to guide our laws. But we don't have enough, like you're saying, there was that concept of the 4th District judge that said, well, you deal with it as it comes up. That's not the best way either, because if you do that, then you can't prevent, or have a system to deal with the man that you were talking about in Texas who just shot everything up. So, I mean, do you think together potentially there would be a blending of both of your ideas and viewpoints that would create a concept for a system that could take originalism and sort of more Senate influence and, more influence from other parts of the law besides the Constitution that works together?
What do we disagree about, Akhil?
Yeah. You worked for Trump. I never would have. Just saying.
You want bad people working in government, or you want good people taking those jobs?
No.
I expected a thank you note.
And you're right. Actually, I'm grateful that there was some adult supervision for a moment. So we do agree on a lot because my friend is a very reasonable person. I try to be a reasonable person, and we're trying to model conversation. And that doesn't mean we've always voted for I was, not being just a jerk. We haven't always voted for the same people on election day, but we try to see the best in our political conversation partners. That's what we're supposed to do. She's had me on her podcast. We're gonna have her on ours, and that's good. You're asking also about, there are different time periods. At some point, if people really want to talk more about guns, I'll show you a fun graphic, but maybe we'll get into that a bit. Here's one thing that she did say that I just want to highlight. The Second Amendment is particularly challenging, and I'll tell you a little bit why, and then if people want to hear more, I actually have a slide. Because I think the Second Amendment went one thing at the time the Constitution was adopted, a different thing in Mr. Lincoln's era, and today maybe something different still because guns are so different. So, and I can show you all that in a slide or two, but our society has changed a lot. That's a challenge for originalism. Guns have changed a lot. Oh, and there's more than one actually constitutional moment because there's the founding, which had kind of one vision of arms bearing, and the Civil War amendments, which actually had a rather different vision of arms bearing.
So how does originalism work then? How is it originalism if you're saying the meaning of the words changes?
Well, it's especially easy when there's been an amendment, because it's the later amendment that might modify the earlier words.
But the 14th Amendment, of course, doesn't amend the Second Amendment. It
Oh,
doesn't
of course
change
it
any of
does,
that.
my dear friend. I wrote a whole book called The Bill of Rights, Creation and Reconstruction. And the thesis of the book is that the Bill of Rights, even the phrase, Bill of Rights, it doesn't call itself the Bill of Rights. We call that is the first 10 amendments. We call it the Bill of Rights because people at the time of the 14th Amendment called it the Bill of Rights. Freedom of speech meant something a little different to the founding generation than it did to the Reconstruction generation. How to think about the so-called Establishment Clause, that meant one thing to the founders, a different thing to the framers of the 14th Amendment. And
So which one are we supposed to take as originalists?
The later in time, just as, if we have two statutes, and we often look at the second statute, it might modify the first.
Doesn't that mean they weren't being originalists? If they had a different sense of what freedom of speech meant in 1868 when they ratified the 14th Amendment.
It meant they were amenders, making amends. Here's the most important thing you need to understand about the original Bill of Rights. It doesn't apply against states and local governments. It only applies against the federal government. If you close your eyes and think about a Bill of Rights case, close your eyes and think about something. Probably 90% of you are thinking about a case that, strictly speaking, isn't a Bill of Rights case because it involves a state or locality. It's a Brown versus Topeka Board of Education. It's Roe versus Wade, which is about Texas. It's Miranda versus Arizona. It's Griswold versus Connecticut. It's Escobedo versus Illinois. It's Obergefell, which is about state laws. So most of what we call the Bill of Rights is actually a very interesting interaction of the original 10 amendments and the 14th that makes them applicable against states and localities also, and in the process changes their meaning sometimes in very interesting ways. And this is why I was dumping on Scalia, because he didn't even talk about any of that. So these are the issues that serious originalists have to talk about. You will see these issues very seriously discussed in 3 gun cases. The Supreme Court has handed down 4 gun cases. First one doesn't discuss this at all. It's a case called Heller. It's Scalia, and it's not very serious. Then there was a case, and Heller said that a person had a right to have a gun in the home for self-protection, and this was a case involving the federal government, technically D.C. I think that was rightly decided, but Scalia doesn't actually really talk about any, in a smart way, about, for example, the framers of the 14th Amendment, who very much believed that people had rights to have guns in the home for self-protection. The next case that comes along, these are 4 justices, 4 gun cases. First is called Heller. Second one is an opinion by Justice Alito. It's a case called City of Chicago versus McDonald, and it basically says, not only can the federal government not mess with a right to have a gun in the home for self-protection, states and localities, in this case, the City of Chicago, can't do that either. It's written by Justice Alito. There's a concurrence by Justice Thomas, and it's much more serious because it actually talks about, there's this Second Amendment vision, and there's this 14th Amendment vision. And then there's this third case, and it's a case called Bruin, and it's authored by Justice Thomas, and it has a very detailed discussion of the 14th Amendment stuff, which Scalia, you see, never did. And then there's this case called Rahimi that you mentioned, authored by Chief Justice Roberts. And actually, when you go into all the opinions, there's some interesting discussion about, how do we think about the 14th Amendment? How do we think about the founding? How do we think about guns today? And Scalia didn't do a very good job in that first case of really bringing the 14th Amendment into the frame. We today are children not just of the framers, but very much of Abraham Lincoln and his generation, a generation that ended slavery, that provided for civil rights and applied them against states. that eventually would commit themselves to voting rights for blacks. A serious originalist project has to look at the whole Constitution, including all of its amendments. And Scalia wasn't so good at that, but actually I think the court in the more recent cases have done a better job of that.
Okay.
Thank you.
You bet. We don't have to clap after every answer.
All right. So I work here at Brown in public safety, and I have a lot of free time on my hands sometimes. And I cannot put your book down.
Thank you.
So when you pick this book up, you're going to lose a lot of sleep because I cannot put the book down.
That's very generous of you. And we haven't met before. He's not a plant. But thank you.
But
thank you, my friend.
So my question is actually Article 1, Section 9, Clause 1. My question is, if Congress imposed a tax or duty on said persons' importation or migration into the U.S., would that have unraveled the project sooner? Would that have caused a civil war sooner, or would that have ended slavery as we know it?
So I think that there are three big themes of the Constitution. They're the same three themes that my teacher of ancient Greek history, back when I was a Yale College undergraduate, taught me. He said one day in class, he just, by the by, you listen to your professors, and sometimes when they're just sort of talking about, something tangential, that's when sometimes the most interesting pearls of wisdom drop from him. He says, well, Greek history is basically about democracy, slavery, and war. I said, Lord, that democracy, slavery, war. The Constitution is basically about democracy, slavery, and war. Those are its three big themes. We haven't talked so much about slavery, although I've hinted at it by talking about Mr. Lincoln's generation. And you're reminding us, and this is Article 1, Section 9, because you've read your Constitution, about a clause that we today call the Slave Importation Clause. And it basically says Congress can't prohibit, it can prohibit anything else from coming into the United States. It can prohibit shovels. It can prohibit plows. It can prohibit grain. But for the first 20 years until 1808, it can't prohibit the importation of slaves. And the Deep South insisted on this as a condition of ratification. They weren't going to go for the project unless they had some protection for 20 years, a 20-year window to import as many slaves as possible. Now, we got lucky in America. See, Scalia, if you're originalist, you don't look in dictionaries. That was what she called 1.0. That's what Scalia did because it was easy to do, okay? But Scalia, that's not, originalism is actually understanding the history behind the text. It doesn't say slave here. Actually, let me read it to you. The migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. So you can have a $10 head tax on it. It doesn't say slave. And if you're just looking at dictionaries, you won't know what this is all about. This is about slavery, and it's an accommodation. The Electoral College is all about slavery, you see, because if you have a direct election system, the South will lose every time because the slaves don't vote. But with an Electoral College, you can count your slaves, albeit at a 3/5 discount, and Virginia's going to be the big winner because it's got lots of slaves. So Scalia, I'm not a fan of Scalia, okay, because he didn't know history, and he didn't read books. And he called himself an originalist. He was a poser. I'm a much bigger fan of Clarence Thomas because he reads books, and that's why I want you to read books so you know your history, you know the history behind it. So that clause was all about slave importation. And without that, the South wouldn't have actually, the Deep South wouldn't have agreed. The Deep South, by which I mean especially Georgia and South Carolina is importing lots of slaves. Virginia isn't. It's producing more slaves than it can use because Virginia slavery is much kinder and gentler. And South Carolina slavery kills people very fast. You make a lot of money off of them, but it kills them very fast. So they need more and more and more slaves to feed the slave machine. And Virginia doesn't. So there are differences between the North and the South. There are differences between the Upper South and the Deep South. Now, this is real originalism, understanding the history behind the thing. This was a bad provision of the Constitution. It's not the only one, okay? And it would have been way worse had the South been able to import as many folks as it thought it was going to when it ratified the Constitution. Does anyone know why the South ended up not importing nearly so many slaves in this first 20-year period? And in 20 years, under Thomas Jefferson, actually, Congress prohibits the international slave trade. Not slavery, but the international slave trade. So it does it at the first possible moment, and good for Congress. But the South, the Deep South, was betting on the fact that by 1808, we'll actually have enough slaves and we'll be able to count them in that Congress at 3/5 in the Electoral College. We'll be able to stop even a ban. That's what the bet it made. It didn't pay off. Does anyone know why, actually, we ended up importing many fewer slaves than South Carolina was hoping? Okay. Yeah.
I think, well, part of the reason is during the American Revolution, the slave trade pretty much.
The Americans do boycott British goods, including slaves, for a while, but after that, South Carolina is going back, and Georgia and North Carolina, to importing lots of slaves, and they think they're going to import a lot more, but Great Britain will ban actually slavery in 1833, and that's going to happen a little bit later in our story. They don't actually end up imposing a tax, which they could have, of $10 per person. I promise you, by the time you've read the books, you'll know. Okay, because this is actually important. We lucked out big time. Yeah.
Was it maybe that the trade itself had been largely domesticated in the States?
They still, no, they want more and more and more, and they want them not just from Georgia, but from Africa and the West Indies. And that might give you a hint about what happens and why. Yes, there's a revolution in Haiti, led eventually by Toussaint Louverture, a slave revolt, and this freaks the hell out of the South Carolinians because they don't want to start importing black people from the Caribbean who know how to kill white people, who know how to lead slave revolts. And actually, John Adams is kind of pro-Haitian revolution. Thomas Jefferson, very much anti-Haitian revolution. The Brits don't recognize Haiti until the 1830s, the French until 1825, and Haiti has to pay a lot of money for this recognition. The US doesn't recognize Haiti until Abraham Lincoln in 1862, and the Haitians are still suffering, truthfully, today, because of some decisions that were made early on. And I'm not making it up that at presidential debates, people are talking about folks from Haiti, in Springfield, Ohio. So you need to know your history. American has the first republic in the New World. Haiti had the second, but it was a black republic led that resulted from a slave revolt and insurrection, which really, really scared Southerners like Thomas Jefferson. And that's all in that one little sentence that you brought to our attention, my friend. That's what originalism is really about, is knowing the history behind the text. And dictionaries won't tell you that, which is why you need to read big, fat books to actually know what it's all about. I'll say it one other way, because we're in the middle of a presidential election season. I just told you in passing, the Electoral College wasn't a balance between big and small states. It's not because they didn't believe in democracy, they put the thing to a vote. It was all about slavery. A direct election system, the South would have lost every time because it can't count its slaves. But with the Electoral College, they can count their slaves at a discount, 3/5. 8 of the first 9 presidential elections is won by a Virginian. 2 terms of Jefferson, 2 terms of Washington, 2 terms of Jefferson, 2 terms of Madison, 2 terms of Monroe. You need to know that it was actually all about slavery. If it were about big and small states, how come the small state guy never wins? We've only had 4 small state presidents in all of American history. Franklin Pierce, Zachary Taylor, Bill Clinton, and Joe Biden, that's it. It's not about big state, small state. It's not because they didn't believe in democracy. It's about slavery. And when you read, you can pick up lots of provisions, and you'll see so many interesting things once you know the history behind it. So thank you for that great question, because I told you the good things about the Constitution, but I have to tell you, the not so good things, and slavery ranks very, very high among them. But the amendments make amends for some of that. And later on, if you ask, I'll show you how guns fit into this whole story of blacks coming into the story, because it does in a really interesting way.
I'm
All right,
also happy to defend the Electoral College.
Okay.
Like?
Well,
Not at the founding. I just mean today's, but.
And I actually don't. I think there are reasons for it today. Go for it.
Oh, I mean, if you got rid of the Electoral College today, you would have presidents only. It would hurt our polarization, make us far more polarized. As someone who's worked on many presidential campaigns, you would run only national elections. The swing states actually switch a lot. Georgia's obviously a new one. Ohio was one for 10 years. That's about it. I mean, it decides 2004, and it's already off the map. California, of course, was a swing state. Texas used to be a swing state, and they will run only national elections. There will only be national issues. You will run in the largest population centers. Anything that is not a large population center won't matter. And it will make our polarization far, far, far worse at this point. I am for changing states from winner take all. You should have to win each congressional district. That's fine. It would break up some of the states a little, but if we simply went to popular vote, it would be a huge mistake right now.
okay, so in the interest of time, why don't we collect 2 questions on either side? We can kind of correlate some of those and then give you a chance to respond. So, yeah, please.
Wish we had more time because I have so many questions for you. So I guess if I have to pick one here, you were talking about how originalism removes the influence of the judges or justices' individual opinions. But if the requirement for originalism to be effective is to have a great understanding of history, is that not just kicking the can down the road a little bit to require a judge that is educated in history as opposed to a judge that might have a better understanding of the modern conditions that they're ruling on?
It's a huge problem right now within even conservative conversations about originalism, because we're talking about the Supreme Court, and that's what all of us sort of focus on, are these 60 or so merits decisions a year. But think of all the time it took to write Bruin or Rahimi, and now you're a circuit judge and you've got 1,000 cases a year. Now you're a district court judge and you've got several thousand cases to decide a year. How are you supposed to be a lawyer, a judge, and also, by the way, like a very good in-depth historian of all of this stuff? It's a huge problem.
You're right. It is a huge problem. I'm going to lay all my cards on the table and tell you, my sense of the thing. All Americans need to know way more about the history. We all need to become more originalists, truthfully, to hold the Supreme Court accountable so that when they make stuff up, like saying ex-presidents are immune for their criminal misdeeds, bullshit, okay? But you don't know it's bullshit because you actually, so we have to have a much more constitutionally literate society. We academics have to pull our heads out of our posteriors and actually write things that aren't about our personal politics, but try as experts to lay out the facts that we've uncovered in our research, whether they are left, right, or center. We need to present this material to judges because they can't be experts on everything. So we need to help them with amicus briefs and the rest, and they have to actually reciprocate by paying attention to serious scholars who are actually not trying to be partisan about the thing. So
You get cited plenty.
yeah, but I'm being now honest. In the New World Order that I'm imagining, I'd be cited 10 times as much as I am now because I've written these books, and my colleagues aren't doing that, and they should. And if they do, then they'll have more books to choose from, and we can actually, this is how science works, whether findings are replicable if other people say Amar just made that up, or actually, we find the same result. So scholars actually have to, right now, the ecosystem is going to be very difficult because judges can't be experts on this. They can know what their own gut is, but they can't really know so much about all of American history. And I want them to do that because that's what they took their oath to. And because there's a lot of wisdom in that and in what we, the American people, have done over time. But it means scholars have to do a different job than what they're doing now, which is pushing their own politics. And it means judges and justices have to be more open to what serious scholars are trying to offer to them. And all of us need to have at least a slightly better civics understanding of our system. So I'll say one other thing. We're at one of the great universities in the world. I don't want to embarrass you, but I'm guessing that fewer than 6 of you right now could stand up, close your eyes, and recite all your presidents. Okay? And that's how we die as a people, okay? Because you know more about baseball and football and the Olympics and Taylor Swift, and I have nothing against any of those things, than you do about the Constitution. But the only thing that we have in common is the Constitution. And that's why this is Constitution Day, and I'm using it as an opportunity to encourage you all to study it more. But it's a great question, very fair.
Also worth just adding that Scalia, you're going to be much more in the Scalia frame here. He said that judges looking at history was like walking into a crowded cocktail party and looking for your friends. That too often you'll be inclined to find the history that agrees with the position you sort of had in your gut and be like, check, I did history. And that it's a problem. But that was Scalia's point. Okay, you said we should take 2 at a time. Sorry.
Yeah, let's take at
two
least
at a time.
Yeah.
So,
But thank you. It was an excellent question. I know you had many, but you picked a good one.
thank you for your time.
So I'm a pretty big fan of U.S. history, specifically presidential history. Mainly think that guy, who is the best public safety officer and also dad. But also, I'd like to say that since I'm so focused on presidents, I have to make my question about it. So, so we hear a lot about presidents, certain presidents or certain presidential candidates who I will not name, but I'm sure everyone has an idea in their mind, who either do adhere by the Constitution or don't, especially in our modern history. And you hear a lot of exaggerations, like saying this will be the most important election. I think that's 1860, but I digress.
I think you're right.
Thank you. And I say that because there are a lot of exaggerations in modern history, but one could say that modern candidates or presidents, you'll hear from one side that they respect the Constitution the most, other sides that they don't, they respect it the least. But which president in history would you both say respected and adhered to the Constitution the most, even more so than their own ideologies?
Lincoln.
Okay, wait, next question.
That one word, yeah, but I'm done.
Okay.
Lincoln.
Okay. Really? That's weird. Okay.
My question's about Fourth Amendment jurisprudence and how that relates to technology, since the newer technologies make clarifying what's a search much more difficult. Like with U.S. v. Jones, I think Scalia tried to keep that originalist perspective and compared it to the tiny constable carried on the car. But do you think that trying to tie it back to the founding era will still work when there's new technologies like drones and AI technologies that can recognize someone's face? So at what point will originalist thinking not hold up with new technologies?
Okay.
Yeah.
Keep that in check.
Okay.
Okay.
I basically had the same question.
Okay.
Love the Fourth
Good.
Amendment
So it's
question.
an important question.
Okay.
Shared by 2.
Okay. Okay.
Awesome. Let's add one more. Talia, you want to jump in?
Yeah, I had a question about levels of scrutiny. I know you mentioned Rahimi and Justice Kavanaugh's what he wrote about
Concurrence.
levels of scrutiny, and I was
Concurrence.
just yes, sorry, thank you, concurrence. And what you thought about levels of scrutiny in general, but also in the context of gun control.
Yeah.
Yeah.
Okay, on the Lincoln thing. So obviously everyone's going to go to Lincoln, but I would argue that Lincoln has a wonderful sense of what he is preserving and is willing to be extra constitutional for the sake of preserving the document, but that in and of itself, obviously he's going to lose some of those cases down the road.
He was really, I think that's how he's often been portrayed. He's a total legal stickler, and he doesn't go outside the law. He's the greatest originalist.
He suspends habeas without Congress. Congress could come back.
And he makes a compelling argument, to my mind, that that was completely permissible. And I promise that's at the heart of the sequel book, which I sent off to the publisher 4 days ago. So it's called Born Equal. So let me just tell you who Abraham Lincoln is. He's a nobody from nowhere with less than a year's formal education in his entire life. Why is he picked of the millions of Americans of his race and sex, and actually very low class? And the answer is the following: because he's the most astonishing originalist of the century. This is before the word has been coined. He is a true founder's son who takes seriously what the Constitution actually said and meant, the good and the bad. He hates slavery with a passion. Here's a quote: I hate slavery. Here's another quote: I hate slavery as much as any abolition. Here's another quote: if slavery is not wrong, nothing is wrong. I cannot remember a time I did not so think and feel. Here's another quote saying, I hate to see wretched creatures hunted down, and yet I bite my lip. Okay, so he hates slavery with a passion, but he says in his first inaugural address and at Peoria and elsewhere, I will enforce the Fugitive Slave Clause, okay, because it actually is the law. And it doesn't say slave. He could have played this game. Oh, it says pound of flesh, but not a drop of blood. Doesn't say slave. It's not about fugitive, but it is about fugitive slaves. That's what an originalist would say. And so he has to wrestle with the legacy of the founders. And so here's what he says. And Scalia is such a joke. He's not serious. And Abraham Lincoln is. He should be your hero. And he's a great lawyer. And he says the following: they actually did protect slavery in a bunch of ways. We just talked about, the international slave trade, for example. I don't deny that. He doesn't rewrite history just to make it convenient. But they actually meant to put slavery on a path of ultimate extinction. It's our generation's job to do that. They did say, look, it's right there in front of you. In 1863, how does he begin? 77 years ago. No one can remember what happened 87 years ago in this room. He's making an originalist argument, okay? What happened in 1776? 77 years ago, our fathers brought forth upon this continent a new nation conceived in liberty and dedicated to the proposition that all men are created equal. And they said they didn't do it, but they wanted to do it, and it's our job to make amends, to redeem it, to fulfill it, okay? So he doesn't cheat. He actually, and you read Cooper Union, oh my God, it's originalism. So he says, he goes through all the signers of the Constitution, one by one, and say, that guy voted to prohibit slavery in the territories, and that guy did, and he names them all. And Americans elect him because he takes the Constitution seriously. His inaugural address is all about the oath of office and taking the Constitution, and he will enforce provisions that he doesn't like. Okay, but he will also give America a telos, a vision. We are a people who did enslave, okay, but we immediately in the North got rid of slavery in places like Rhode Island and Massachusetts and New Hampshire. America, the ancient world, everyone had slavery, and there was the freeing of slaves from time to time. Ben-Hur, a funny thing happened on the way to the Forum. Individuals are freed in the Old Testament, New Testament. But Jesus actually doesn't talk about this. In the world, one nation originates the idea not of freeing slaves, but ending slavery. Not manumission, not emancipation, but abolition. It is the United States. In 1775, the world's first abolition societies formed in Philadelphia. And immediately after the Declaration of Independence, the North actually starts to free its slaves. The Deep South doubles down. That's South Carolina, that's going to lead to a civil war. And Lincoln, he's so honest, and he's going to say all of that. They actually didn't get rid of slavery, but they were opposed to it. That's why they said all men are created equal, and it's our job to redeem that and fulfill that. Oh, he's a brilliant originalist. He doesn't cheat. He doesn't go extra legal. That's what all sorts of people are taught, but they haven't read the book.
That isn't out yet. Look, Lincoln's the right answer, but I do think it's worth noting that it's a real race to the bottom. George W. Bush has a signing statement when he signs the Bipartisan Campaign Finance Reform Act, where he says, I think parts of this are unconstitutional, but I'm signing it anyway. What's his responsibility to uphold the Constitution if he's signing something that he believes violates that Constitution?
I agree with my friend on Sarah on that, and I actually criticized him at the time for just that.
And I'll take Joe Biden. He says repeatedly that he doesn't think he has the power to forgive student loan debt, does it for the purpose of having the Supreme Court strike it down so he can run against the Supreme Court and blame them. I think that's a horrible violation of his constitutional duty.
I agree with my friend Sarah on that.
So for all the
See,
focus
if you have ground rules, you can actually sometimes, because you're playing by the same ground rules. I agree with you.
Donald Trump deserves some of the focus that he gets on his total disregard for the Constitution, but a lot of other presidents deserve some attention on it as well. Okay,
Do you
Fourth
wanna
Amendment.
deal with the search and seizure question?
Fourth Amendment. Fourth Amendment.
So the book begins, Act 1, Scene 1,
Oh, God,
with
we're
a
gonna read the
great
whole
search and seizure case. It's called the Writs of Assistance case. So you want to read that. It's all about. Now, here's the point about originalism. It actually doesn't answer every question. At its best, it's going to tell you what's an easy case for applying an idea and what it's not about at all. That's about all originalism can do. It sometimes can answer certain questions. They may not be the questions that you want answered today. So now, here are the big questions, actually, the Fourth Amendment. You're interested in new technology, and I'm not going to be able to tell you very much about that. She says guns are different, and she's right. And the Second Amendment and the 14th Amendment may not tell you everything you need to know if the technology changes. But here are the three biggest questions, and they're teed up in an article in the Harvard Law Review called Fourth Amendment First Principles, and you can guess who wrote it. And it has been cited multiple times by the Supreme Court, and here's what I say, contrary to what the stupid justices say, because they actually are getting it wrong. Here are the three questions. One, what does the Fourth Amendment require? The court says it generally requires warrants. It actually doesn't. The court also says, it generally requires probable cause. It actually doesn't. What it generally requires is reasonableness, which is different than warrants or probable cause. The court says, what's the remedy? The exclusionary rule. No founder believed in that at all. Actually, the Fourth Amendment was originally, if the government searches and seizes you unconstitutionally and you're an innocent person, you sue them for damages, and there's no such thing, none of these immunities that courts have created. It was a better world for innocent people. It was a worse world for criminals. Now, you're asking one other question. What counts as a search or seizure? Amar says, if a search or seizure only requires reasonableness rather than warrants or probable cause, we're going to be much more open to the idea that many, many things are searches and seizures because they won't require warrants invariably, they won't require probable cause invariably, they'll just require reasonableness, and we'll be able to call honestly all sorts of things, surveillance and all the rest, searches, because we actually will be looking at the Fourth Amendment. And this is all laid out in a piece called Fourth Amendment First Principles. But the first chapter of this book is all about what happened in New England, in Boston. It was a very interesting search and seizure case called the Writs of Assistance controversy, in which John Adams very famously said, then and there the child independence was born. Then and there the seeds of patriots and heroes were sown. It won't answer all your questions about new technology today. I don't think any constitution could, but it'll at least answer some questions about what the Constitution really does say about searches and seizures.
Awesome. Okay, so we are actually at time, but our remaining questions, if you'd like to come forward and have a chat and raise them independently, I welcome you all to do that because that's what we're here for. But for the rest of us, please join me in thanking both of our speakers.